like to welcome you all. My name's Jasmin and I am the Schools Program Coordinator at the County Court. And I'd love to welcome our three judges this morning. We've got Judge Carmody, Judge Chambers and Judge Doyle. Before we begin, I would like to acknowledge the Wurundjeri people who are the traditional custodians on the land which I'm on, and I'd also like to pay my respects to their elders, both past, present and future of the Kulin Nation, and extend the respect of all other Indigenous Australians present. So this morning is going to be, I know quite a few of you have participated in a school session before. It's going to be very similar to a school session where the judges are going to introduce themselves and then we're going to ask some questions. So I would encourage students or teachers that are acting on behalf of their students, if you could please either send them through in the Teams chat, or if you'd like to ask a question, feel free to raise your hand and we can select you to answer a question. So with that, I will stop talking and hand over to Judge Carmody. Thanks, Judge.
Right, this is a few brief words of introduction as to who I am or where I come from. So I grew up on a wheat and sheep farm in the Wimmera Mallee area. Had the good fortune of going to school like all of you are, and then went to university, did law and commerce, practiced as a solicitor for 3 years, went to the Victorian bar as a barrister for longer than I should have been there, but anyway, for 27 years. And then out of the blue, I received a phone call from the then Attorney General to ask me if I wanted to be a county court judge, and I was the most surprised person in Victoria, but in the event I said yes, and here I am, and I've now been a county court judge for 10 years. So any of you out there who want to do anything to do with law, it's all in front of you and it's easy to do. Welcome.
Thanks, Judge. Judge Chambers.
Hello, everyone. My name's Mandy Chambers. I, by way of background, left school in year 11 and did other things that didn't work out for me. And I then made the decision to go back to school, to the local state school, and finish year 12, which I think was probably the best decision I ever made, going back to school. Not an easy thing to do when you've left school. And I then, frankly, did far better than I expected to do in year 12, and I got into law arts at Monash, completed that, then worked as a solicitor for quite some time until I was appointed a magistrate in 2006. I then worked as a magistrate for about 9 years until, like Judge Carmody, I got a call from the attorney and I was appointed a judge of this court, but also president of the Children's Court, which was a role I had for about 5.5 years, and now I'm at the county court. So that's just a bit by way of my background.
Thanks, Judge. I want to hand over to Judge Doyle.
Morning, everyone. My name's Kevin Doyle. I grew up in Melbourne and I finished school in the early 1980s, and I then went to Monash University and I did arts and law at Monash University. Finishing that, I worked as a solicitor in criminal law at Legal Aid and various other places, the Aboriginal Legal Service, until 1995. I was a barrister from 1995 until about 2018. I was then a Crown prosecutor for about 18 months. And a bit like Mandy, I was about to go into court and I got a call from the Attorney General, and I told her I'd have to call her back. And I did later on in the day, and she asked me if I wanted to be a county court judge, and that was a couple of years ago now. And I said yes to that. And so here I am a few years later as a county court judge. So that's my history.
Thanks very much, Judge. Whilst I have you, Judge, I might ask you the first question of the day, and that is, how do all the divisions different, and do matters ever overlap between civil and criminal jurisdictions? And what are some of the examples or quasi-criminal matters?
Sure. Well, the county court has three basic jurisdictions: the commercial division, which deals with commercial disputes, commercial litigation, and that is in fact the smallest division of the court. Then there is what's called really the common law division, which deals with the civil disputes where people are suing each other. But the substantial part of that jurisdiction is personal injury cases. And then finally, the largest jurisdiction in the county court is the criminal division, which all three judges that are here this morning sit primarily in the criminal division. The criminal division hears most of the serious criminal offences in Victoria, other than homicide, being murder and manslaughter. The court hears criminal cases from theft through to dangerous driving, causing death, and culpable driving cases, and everything in between. Of the criminal division, a significant portion of the work is sexual offences. So those are the three divisions in the court. There is reasonable overlap between some of the areas of civil and criminal. I mean, you may understand that some civil wrongs are also crimes, such as assault. One can always sue in the court for assault, but that's not a substantial overlap. But for instance, some areas of these, at the end of a criminal case, there may well be damage occasioned by the victim of the crime, for instance, in a sexual offence or an assault. In those circumstances, after an accused has either been found guilty by a jury or has pleaded guilty, the judge has a power later on to make a compensation order in favour of the victim in such a case. So in a sexual offence case, that person can come before the court later on and make a claim for compensation, and that's a jurisdiction the court has that overlaps with the civil division. It's not a criminal jurisdiction, it is a compensation payment that follows on from a criminal finding, but it's heard in the county court, and that's one instance. Another example of a similar nature is forfeiture proceedings. In, for instance, a large drug trafficking case, the prosecution are able to seek forfeiture of property and money obtained as a result of such crimes, and those matters, whilst not strictly criminal, can also be heard by a judge in the county court. There are other areas, such as in sexual offences, once an accused, in certain circumstances where an accused has finished the sentence but is still considered a risk to the community, orders can be made for supervision of that person in an ongoing way for many years after the conclusion of the sentence. They're called post-sentencing orders. They're made by judges and they're reviewed by judges on a regular basis for years after. So that's another area where the court is occupied hearing cases concerning ongoing supervision that all stemmed in the first instance from a criminal case, but which leads to ongoing court proceedings for years involving supervision. But so there are these various areas that all stem from crime that overlap. The other instance which has some similarity to crime is, for instance, if in the magistrate's court a person obtains an order for an intervention order for family violence or the like, the substance of what the applicant may be alleging may well involve criminal activity, but the order made is a non-criminal order, a family violence intervention order. Now, those proceedings can be appealed to the county court, and in that circumstance, we would hear such a matter. And whilst that's not a criminal matter, it often has significant similarities to a criminal matter and often involves allegations of criminal conduct. So there are those various overlaps between the civil and the criminal division. So I hope that answers that question. There are others, but we could probably talk about it for the rest of the time we've got, so I won't do that.
Thanks very much, Judge. I might pass over to Judge Chambers now with a question. When you come across young adults who are involved in hearings, do you treat them any differently because of their age?
So we certainly do. Firstly, talking about children in particular who come to court who are said to be victims of offending, including victims of family violence or sexual abuse. In the old days, they used to come into court and be cross-examined just like any other witness. But there have been significant reforms, particularly in relation to victims of sexual abuse. And now we have a very bespoke approach to the way in which we treat children, particularly as witnesses. They give their evidence generally from a child witness service that provides a lot of support, both emotional support and prepares young people for the experience of giving evidence in court. There is now an intermediary program where young people are assessed by people with qualifications such as psychology or neuropsychology, and they inform the court about their ability to understand questions. And we then hold what's called a ground rules hearing with the lawyers together with the intermediary and discuss the way in which questions will be asked of the child. It's not to change their evidence or otherwise influence their evidence. It's just to make sure that young people can understand the questions that are being asked so that they can give the best evidence they can. So when it comes to them giving evidence, and there's a separate special hearing for them to give their evidence, they are supported by often the child witness service, someone providing emotional support for them, and the intermediary sits there to make sure that they're understanding the questions that are asked. So, and once those proceedings are recorded, they don't have to give their evidence again in court, even if there's an appeal or a retrial. So that's a very different way we treat children in the criminal process. But when young people are before the court being sentenced, we also have different rules that can apply. For children, there is a completely different sentencing regime for anyone who's under the age of 18. In Australia and in Victoria, no child under the age of 10 can be charged with a crime. They're conclusively assumed to be incapable of forming the intent to commit a crime, so they cannot be charged. And up until the age of 13, a presumption that they don't have capacity, it's called Dolly Incapax, needs to be precluded by the prosecution before the charges can proceed. And in the children's court, when we're sentencing young people, very much the focus is on supporting and fostering their rehabilitation. And we look at therapeutic jurisprudence to do that and providing supports and diversionary programs so that they don't become entrenched as young people and then as adults in the criminal justice system. Sitting in the county court, we still take into account the youth of a young person, but it very much, the degree or the weight you attach to youth very much depends on the seriousness of the offending that they are being dealt for. Very often you will hear judges say when sentencing that for serious crimes, the sentencing considerations of general deterrence, which means not only sending a message to the offender before you, but also to the community more broadly about the ramifications and risk, frankly, of going to jail if you commit serious offences, is a message that we're sending more broadly to the community. And what the law does say that for a young person, for a number of reasons, the need to send that message more broadly is reduced. And it does so because the law generally recognises that young people are more immature, more prone to impulsive decision making, but also significantly their very youth means that they are an appropriate vehicle really for rehabilitation, and that the whole community benefits when a young person is rehabilitated. The community's safety benefits when a young person is rehabilitated and turns their life around and goes on to lead a very productive life. So those sorts of sentencing considerations can come to the forefront with a young person. And it's also recognised by the law that adult imprisonment is very much an option of last resort for a young person, particularly a young first-time offender. And generally the law treats anyone under the age of 21 as a youthful offender. So what we have unique to Victoria is what's called a dual track system, so that a young person, if they're found guilty of an offence but are particularly vulnerable if they were to be sentenced to an adult custodial sentence environment, to the influences of older, more entrenched offenders, or whether if the court finds that they are a young person with very good prospects of rehabilitation, we can sentence them to a youth justice detention centre. So in other states across Victoria, that wouldn't be available. Across Australia, that's not available. Once you turn 18, you're at risk of going into an adult jail. But in Victoria, we bring a more bespoke approach to those young people to try and keep them out of the adult criminal justice system to promote their rehabilitation. So there are real examples where you may have young people committing what are seen to be objectively quite grave, serious offences, but for all those reasons, they may get what's seen as a more lenient sentence. And that's simply because youth carries so much weight when sentencing a young person. But there are cases like culpable driving, for example, where young people are involved in highly dangerous driving activity that poses real risks to both themselves, often other young people, or to the community, where the law says, well, youth will carry less weight because we do need to deter those young people and deter other young people. And so general deterrence then will be given greater weight in the sentencing equation. So these can be very difficult cases where you have young people charged with very serious offending, because getting that balance right is the very difficult aspect of sentencing in those cases.
Thanks, Judge. We've got some fantastic questions coming in, so thanks very much, students. I might pass over to Judge Carmody now. Why are pre-trial procedures necessary, and what does a committal and directions hearing involve?
Welcome, students. You can imagine just how thrilling all of that is, all procedural matters. But let me give you some examples. First of all, committals are conducted in the magistrate's court, and basically the test is if there's sufficient evidence for a jury to convict someone of a crime, then the magistrate will commit them. Once they're committed, they come here to the county court, and then comes our procedures jump into place. So that's the first stage. A committal proceeding they come here to the county court. Then here we manage those cases by way of directions hearings, and really they are just management hearings to determine witnesses' availability, when the case can get on, which judge is going to hear it, those sorts of things. And I won't go too much further into that because that's about as interesting as eating chaff without a glass of water. But I'll tell you this, though, we then also have pre-trial procedures, which are beyond the directions hearings. And just two examples of what they are. So one example would be, say, a sentence indication hearing. That could be considered a pre-trial procedure. Really what that's about is the accused is coming along to court with the prosecution. it's really what one might describe in layman's terms as putting a toe in the water. So what they do is they come along, the prosecution have an agreed statement of facts about the hearing if it was to be dealt with as a plea of guilty. And the offender comes along with his counsel or barrister, solicitor, and they have these submissions they'll make about sentence, and they want to know from the judge what's the likely range of outcome, and if it's within a tolerable result for the offender, they might plead guilty, and then that judge will deal with the sentence there, and in that way. I'll give you an example of one of those I had in Ballarat. I see some of you from Ararat, so I'll give you an example. One day when I was much younger as a judge, and it was the first sentence indication I was ever put in front of me, and I have to tell you, there's never been one since. But and I'll tell you, you'll get the idea, and I'll tell you this story. So, for those of you doing, is economics still taught in schools? I think it is as a subject. It is. So, this also involves what you would have heard as a concept in economics is vertical integration. So you would have been told in economics that's BHP, they dig up the iron ore, they make the steel, they sell it through, in the old days, used to sell through blue scope steel. That's the roof on mum and dad's house. That's called vertical integration, from the mine to the end product. So this is also a case of vertical integration. The accused man was a doorman at a nightclub in Ballarat. He was also a doorman security man. So obviously for all you young people who go to nightclubs, he's the first person you meet as you go into the nightclub. And you have, if you go to the same nightclub, you have sort of a nodding acquaintance with the door person. That's the first part of his job. The second part of his job became a little bit more obvious when the boys in blue, as I disrespectfully refer to the police, turned up with a warrant at his farm just outside of Ballarat. And when they opened the shipping container at the back of the big shed on his farm, there's this great big machine sitting up right in the middle of this shipping container. For those of you who know, they're about 20 foot long and 8 foot wide and 9 foot high. So this machine has nearly filled up one half of the container, and it was a pill press, one that you might find in a commercial drug company. It was wired up wired up so it could run this commercial machine, and the powders were put in the top and it made the pills. So that's what this case was about. This was a man who was charged with having machinery involved in drug production and sale. So the photographs, so they're putting this pitch to me that it's a non-custodial sort of disposition. I have to say to you that didn't readily appeal to me. So I asked whether or not there are any photographs of the scene. And so, oh yes, Your Honour, there are. So anyway, they hand up a book of photographs, and here are the photographs. Inside this container were a number of things other than this pill press. One of them was a small ladder. Oh, what's a small ladder for? Oh, that's so the person can reach to tip the stuff in the top of the machine, Your Honour. Oh, right, okay. What's this? What's that? There are a number of other things. Anyway, for those of you who are from Ararat, you'd be familiar with the brand name Hames, as in Hames paint. So there's a Hames paint tin on the ground with a bit of red paint dripping down the side of it. And I said, well, what's the paint tin doing there? And oh, that's to colour the pills, Your Honour. I'm telling you that story so that next time when you're offered some eckies in the local nightclub and they're pink in colour, just remember you've got some Hames paint in there with it, and you've got no idea what else is in the tablets. So that's pre-trial procedure. That's one version. The other one is to do with, it's really to do with management of the trial. So sometimes you make rulings about evidence that might end up meaning the prosecution's case becomes nothing. You rule out the critical part of the evidence for either because it's illegally obtained evidence, or it's just evidence that is not properly before a court. And so if that happens, then the trial just disappears because the prosecution have to reassess their case, and they realise they haven't got the critical evidence. Out it goes. On other occasions, say for example, in a record of interview, that is an interview between the police and the accused person, it may be that the accused is hopeful that they'll get their record of interview out because they've, yeah, I've done it. You know, they've admitted it during the course of their record of interview, the offending. But if the record of interview is out, then the case for the Crown is the prosecution is very weak. And so that they run that as a pre-trial issue. Let's get rid of the record of interview. But if it's ruled in, sometimes the game's up, as it were, and they plead guilty. So that's the benefit of pre-trial procedures. It narrows down the issues in a case, but it's also capacity to finish a case altogether from a trial setting into a plea, which is a plea of guilty when I say that. I think that's probably enough of the examples for you. There's any number of them, but time short. Back to you, Jasmin.
Thanks very much, Judge. Whilst we're still talking about committals and pretrial procedures, we've had a question from St. Michael's College, and that's regarding the recommendations from the VLRC on abolishing committals. Would that affect the way that your cases are run?
Yes. So judges in the county court, or some of them, particularly grumpy old ones like myself, are really fearful about, well, I'm joking about the fearful part. It will impact on us because it'll mean that there'll be a lot more pre-trial argument before trials. And so really what'll occur is, and will be what was once done in committals, not entirely, but what was once done in committals, where in a committal hearing, if you went there as a barrister, you'd be just trying to test various areas of the prosecution's case and check that you've got all the information in the prosecution's case in your hands if you're acting for the accused man or woman. And so you would, that procedure now will come to the county court as preliminary hearings where parties will seek to cross-examine witnesses, particularly police witnesses, before any trial is listed for hearing. So it'll just add an extra stage, in my opinion. So it'll add to further delays within our trial process that are already being absolutely crucified by COVID-19.
Thanks, Judge. I might pass over to Judge Doyle now. This is a two-part question from both Fintona and St. Michael's, and that is, do you ever have any issues with juries? And do you believe that cases heard by juries are more or less effective than cases heard by only a judge, and why?
Look, I'll answer the second part of that question first. I was always unsure about the answer to this question as to whether juries make better decisions than judges. And once COVID hit last year, we were able then to hear cases, criminal trials as judge-alone trials without a jury. That was for a brief window of perhaps 9 months or so. It's gone now. We can't do it anymore. And I had to hear a judge-alone trial, and I can say I found it very difficult. The burden of making the decision falls upon you alone as the judge. You hear things about the accused inevitably of a prejudicial nature that you have to then try and put out of your mind. And then you have the task of explaining laboriously over about 150 pages in my case why you're making the decision that you've made. And I must say, you bring, as a judge, having heard criminal cases or having been involved in them for a very long time, you do bring baggage to the task. You've had experience with that sort of material before, and you bring all that experience to the task. And it's not necessarily a positive thing, because it makes it more difficult to come at it with a fresh mind. I did always have the view that juries made better decisions, but having that experience, I'm now certain of it. I do think that having 12 people who come to the case fresh from the community, who bring 12 different minds and 12 different sets of life experiences, and even different intellectual abilities, different types of intelligence, does produce, in my opinion, in the end, better decision making. And so I am firmly now of the view that juries make better decisions, and I think there is a place for judge-alone trials. We no longer have them. I think there is a place there when the accused chooses such a thing, to have a judge-alone trial. I think there are some good reasons for that process to continue. But in the end, I do think that juries make better decisions, or are a better way of deciding allegations of criminal conduct. Having said that, there are, of course, cases, and this more goes to the first part of the question, where you can have difficulties with juries. You can clearly have jurors that are disinterested in the case. That happens from time to time, but a lot less than you might think. And in my experience, the juries that I've had and that I've been involved with do take it very seriously. You occasionally have people that aren't interested. I've heard of situations where juries argue in the jury room, and judges get brought into all of that, and juries have had to be discharged from time to time for those reasons. But those are rare events. Having a jury to decide a criminal case certainly is a cumbersome process. I mean, for instance, it means every day you have to have 12 people arrive at court healthy, turn up. Every time there's a legal argument, they have to go out of the court while you decide those situations. So it does take longer. So there are those disadvantages of the process. And for instance, I happen to be down in the Latrobe Valley at the moment, and trying to run jury trials in the COVID environment is very difficult. Yesterday, we had a juror that was a close contact of a tier one, someone who'd been at a tier one site, and I then had to discharge that juror and go ahead with 11, and there was a problem with the accused, and he had to be put on a special video link related to COVID. And then at the end of the day, we found out that someone had entered the court building who, without telling anyone he had COVID, and he reported a positive test later in the day, and the jury had to be sent off. So because of the numbers involved, there are all sorts of problems. COVID throws a real spanner in the works for juries. But in the end, it's my opinion that juries are the best decision makers for serious criminal cases. But having said that, I do think there is a place for judge-alone trials. So that's my answer to that question.
Thank you, Judge. I might hand over to Judge Chambers now. Has there been a time when or is there an example of when a judge might not use precedent when resolving a dispute?
So the answer to that is that generally the way the law works nowadays is a lot of what you're required to do is actually set out in a lot of legislation. So where the sort of the hierarchy of the court system, so in Victoria, we've got the Magistrates Court, then the County Court, which we're on, which is the principal trial court, then the Supreme Court of Victoria, which amongst other things deals with the manslaughter cases that Judge Carmody was talking about, but also is the Superior Court in Victoria that makes rulings on points of law, and generally we're required to follow those, and for good reason, I guess, because you want to make sure everyone's applying the law consistently. You wouldn't want different judges making up the rules as they went along, and you just get very different outcomes, and that's just not fair or just. So the law does require that you do have to follow precedent where it applies to sort of the determination of the law. Where that gets really tricky, of course, is that the facts of all cases are very different, and the circumstances, unfortunately, our job would be a lot easier if every case was exactly the same, but they never are. Every case is so different. And every trial runs differently to the one before. So what you learn along the way is that you've just got to make decisions based on the case before you. And so, yes, precedent will assist, but there will be cases that come before you. And I just had one the other day where you say to the lawyers in front of you, so surely another court's made a decision about this, this change in the law. Surely I'm not the first judge to have had to examine this. And they'll turn to you and say, well, as it happens, Your Honour, you are. And so until that decision goes to the Court of Appeal and they decide whether you're right or wrong about that, you need to make the best decision you can, guided by authorities, but really, in the absence of any clear precedent, you've just got to apply the law as best as you can to the very facts before you. So they're the challenges. We love it when the law tells us the answer, but when it doesn't, we've got to look at the words of the legislation, look at the facts of the case, and unhappily work it out ourselves.
Jasmin, just to interrupt for a moment, look, all the best to all the students listening to this, and I apologise for having to leave the meeting.
Thanks very much, Judge Doyle, and thank you for coming today. So now we've just got the two judges. I might hand over to Judge Carmody, which is what justifies taking a court case to arbitration instead of going ahead with a court trial? Thanks for that question, Zoe.
Yes, well, arbitrations usually are in the commercial area, the jurisdiction of the court that Judge Doyle referred to before, commercial, civil and crime. So in commercial, they can be referred to arbitration. A lot of contractual arrangements between parties, usually big contractual disputes, when I use the word big, I'm talking about money terms, have arbitration clauses within those contracts, and a party can elect to enforce that part of the contract, that is, to have the case referred off to arbitration. The benefit of that is that usually the arbitrator will be either a retired judge or a very senior counsel, as in a silk, as we describe them, who will be the arbitrator appointed. They agree about the arbitrator, so they're both paying the arbitrator. So he or she is an independent person in that sense. They're both paying the same amount. But the advantage of arbitration for those sort of disputes, first of all, it relates to technical, a lot of it's technical stuff. Usually an arbitrator will direct a series of experts to agree about what the expert opinion arrives at. So there might be an expert from one side and the other, and maybe another one appointed by the arbitrator, who will get together and what they call hot tub an area of expertise, whatever's wrong. For example, the building wasn't constructed properly. This should have been built this way, not that way. That's a very basic example. So then it condenses and keeps the number of days and the legal costs and the delay, that is the delay between the dispute arising and the resolution of the dispute by the arbitrator, much shorter. Because in court proceedings, particularly in commercial matters, the problem can arise in 2021 and the judge's answer might be in 2026 or 28. And so meanwhile, these companies are going on. Sometimes they've got to get a really quick resolution and get on with life. And that's the advantage of arbitration over court hearings.
Thanks, Judge Carmody. I might hand over to Judge Chambers now with a question of what are some of the ways which judges and courts are able to make law, and why is there a court hierarchy and why is it necessary?
So thanks for that question. Look, the court hierarchy and the system that has been developed has been in place for a very long time, and it really is for the purpose I think I was trying to explain before, which is that the courts, certainly the Supreme Court, and then the ultimate decision in terms of precedent is determined by the High Court of Australia, which sits in Canberra and is the ultimate sort of arbiter, if you like, of the law. So if I'm sitting as a judge in the county court and there's a High Court authority that tells me exactly how I should apply the law, then I cannot go about making up the law other than to apply the law, but to the facts in this case. Where this has been really a tricky area for the county court is in one particular area that relates to what's often called tendency evidence, and it's about whether or not an accused person has a tendency to behave in a particular way over time, particularly towards different people. And in cases involving alleged sexual offending, it's often said by the prosecution that the court should allow what's called tendency evidence to be admitted and heard by a jury because the accused has shown the same tendency to behave towards one victim as he or she did towards other victims. And it's long been acknowledged that that can be very prejudicial evidence before a jury. Now, the law in relation to tendency evidence in Victoria for a long time was very different from the law that was being applied in New South Wales. The test for tendency in Victoria was far stricter. And so for a long time, judges in Victoria had to comply or apply the law that the Court of Appeal in Victoria had determined. And judges in New South Wales were applying a different approach. And that all then ended up in the High Court, and ultimately they resolved the issue, and we now apply the law as the High Court has said it should. So sitting in the county court, we're not doing much in the way of lawmaking, which is probably a good thing. We're not elected to do that. Our role, being appointed as judges, is really to apply the law that Parliament prescribes. Obviously, there's a lot of discretion in sentencing, for example. The parameters within which we sentenced are set in the legislation, but ultimately there's a lot of discretion on what's often called the instinctive synthesis. So what you are doing as a judge within the framework is trying to balance all the considerations in the exercise of your sentencing discretion to come to the right outcome. So we're not making the law here in the Supreme Court of Victoria. You will have learnt about the common law and judge-made law in the common law, for example, in the area of negligence. From the moment a snail was found in a bottle, the law of negligence has grown, and much of that was judge-made law, but it's also been now set in, a lot of the law is really set by Parliament. So it's an interesting discussion as to whether judge-made law is less democratic than the parliamentary legislative approach, but generally in the county court, I don't know about John's approach, but generally we're not going about making the law.
Absolutely not. Just clarifying about the snail in the bottle, that's different from the snail on the floor of a I Cook place down in Dandenong, which is creating another thing. You might follow that case, listeners. it'll be an interesting case when it comes up to its final.
Thanks, Judge. It's always good to hear there's more than one snail somewhere.
Yeah.
We've had a few questions in regards to emotion and bias. So the first part of this is how much of the emotional impact of the case can influence the jury? And for a judge, have your emotions ever clouded your judgment and bias in a case? Judge Carmody?
Perhaps I better go first, as I'm white and male. When we talk about, when people talk about prejudice and bias, that seems to always come up. Someone who's old like me, white and male, bias is always an issue that courts, it doesn't matter whether it's a judge alone or a judge on a jury case, it's always a live issue, but it's not an issue that we are not aware of. So at the same time, people speak about unconscious bias, which is you can't look into yourself and understand what bias you bring to any decision making or your approach to a decision making process. So the honest answer really is, how can any one person tell you they deal with bias? Because in theory they can't. But you've got to remember, in court proceedings, for example, bias might be demonstrated by, say, for example, friends of the judge being parties in the case. That can't happen. A judge would recuse them or themselves from hearing that case. Now, the next area is friends who are previously barrister friends, for example, of a judge who now was a barrister but now a judge. Can that person appear in front of them? Yes, they can. Is there a bias because they're mates from the past? That is a very difficult question. The answer, I think, is simple. We're all professionals. We as judges particularly have, taken an oath, treat everyone the same that come before us, so that it doesn't matter who's appearing for the party that are in the case before you. That just doesn't matter, and they are the same. That is the barrister themselves. They don't expect any favours, and none are given. So I don't know whether that answers the question about bias, but it's always there. It's always an issue people raise, and it's something that I think all judges are very conscious of all the time.
Thanks very much, Judge.
Jasmin, can I just talk a bit about the emotion side to that? Because there's no doubt that the cases that we hear in court can be really tragic, can be really sad, and I don't think anyone expects judges not to have emotions. I don't think the community want judges who don't have emotions and the experience of others. But what I can say is we're very conscious that we've got a role to play in dealing with that. And so what you can never do is let your emotions overcome what is a just and fair result. So the role obviously is the most important thing we do. And as I said, the law guides you in that respect. But there's no doubt that the work we do in this court carries an emotional punch, and you hear, we hear victim impact statements that are just devastating. We hear about the background of accused people that have just been filled with terrible tragedy of themselves. So, it's balancing all those things to make sure what you're doing is just that remains the challenge. But I'd be lying to say if I were to say that you don't at times have to really concentrate to ensure that you're not overwhelmed by the emotion of what you've heard in court.
Thanks for that, Judge. I'm conscious of the time, so I think we've got time for 2 more questions. And I might ask both Judge Carmody and Judge Chambers to look at this from a civil and criminal perspective, which is how can judges facilitate a fair trial where one party can afford the best legal team and the other cannot? So Judge Carmody, would you like to answer that from a civil perspective, please?
Yes. The first thing I'd like to say about that is sometimes the most expensive lawyers aren't the best. And I say that advisedly. And so when we're talking about affording legal representation, it is a very serious problem in our community, because everyone in our community is equal before the law. But in order to enforce that and make that a practical reality, they also need to be able to be represented if it's in a court proceeding. And so I think the answer is that, first of all, we have unrepresented litigants in front of it. I'm speaking now in civil cases. We also have them in criminal cases. But in unrepresented litigants cases, judges still are judges. They're in the middle, but they, when I say the middle between the 2 parties, but they also, we are charged with, if a person is unrepresented, to the word, I hesitate to use the word assist, because you don't assist a party, but you might direct them in a manner in which they can best present their case. But the party have to organise their own evidence, and they have to do all that sort of presentation of their own case. But they're directed about it through directions hearings that I spoke about earlier by a judge who manages the unrepresented litigants list. And that's how we try and even up the seesaw, if I can describe it like that, between the party with the highly paid silk and junior counsel on the one side, and the other side not having any money and not being able to represent it. I want to add to that, though, that in civil, there's a large proportion of cases done on what is described as no win, no fee. And I'm specifically referring there predominantly to personal injury cases arising from either transport accidents or from industrial accidents, work accidents. And those no win, no fee firms, you would have all seen them advertised on television, so I won't name any of them in front of you. But they take on cases on that basis. That is that if the case is a winner and their client succeeds in money from a contract between that litigant and that law firm, the law firm get paid out of the damages that ultimately are paid over. So there is that sort of bridging in civil. In crime, where a person doesn't have any money, we have legal aid, which is grossly underfunded. I know that's a political statement. I shouldn't have made it, but it's grossly underfunded, and so it's stretched in all directions. Legal aid is stretched in all directions, but people are entitled to legal aid before a court, and courts will order that parties are granted legal aid if it's a trial sort of situation. Very few trials run without legal representation. I'm talking now about the criminal jurisdiction, run without legal representation, effectively funded by the Legal Aid Commission. Yep.
Thanks, Judge Carmody. Judge Chambers, do you have anything to add to that?
No, I think, the most difficult cases in the criminal division are ones where people choose not to have a lawyer, even though legal aid would be available to them. But when they choose not to have a lawyer, they can be very difficult trials to manage, just to ensure that the unrepresented person receives a fair trial. It means we are required to provide them, although we can't give them advice about their case, but to assist them as much as we can to ensure that they are receiving a fair trial. But they are just probably the most difficult cases to run in our court.
Thanks very much, Judge Chambers. The final question we'll ask today is, what advice would you give to students who want to work in the law? Judge Chambers, would you like to start that one?
That's a really good question. Look, a lot of people think to do law, you need to get really good marks. And, so getting into university is only a very small part, though, I think, of being a good lawyer. I think the more life experience you can have, because really this is a very human endeavour, working in the law, you need to know how to speak with people. So the more life experience that you have, the more jobs, part-time jobs you've had, voluntary work you've done, all that sort of thing, all of that contributes to making a good lawyer, I think. I think also everyone's really conscious that the 2021 Year 12 group have done it harder than almost any group of Year 12 kids, and following on from Year 11 through COVID. So if I was to be looking to employ a future law student or someone coming out of law school who'd done Year 12 in 2021, one thing I'd know is that they did it hard, and it showed real resilience and perseverance to do that. So look, I want to end off by wishing you all the very best of luck. I think everyone is very much aware of how difficult this has been for you all. And, we wish you all the very best for this year, for the upcoming exams, and of course for your futures.
Yes, I endorse those comments. In a court of appeal, they would just say, I concur. But can I just say this? When a lot of emphasis, each of you children would have been subjected to a lot of emphasis. You've got to get a whole lot of good marks, and otherwise it all ends. That's not right. Let me tell you, that's not right. First of all, there are other courses you can do if you need to study immediately. Other courses you can do, and from those courses you can get into law course. And you might be sitting there thinking, oh yeah, that's all right for that old bastard to say that. But let me tell you how it works is this, that some students will get into a law course. And if you don't believe me, go and look up the stats. They'll get into a law course, and the first year of law, they'll fail. So at the university, their business plan is, gee whiz, all those places, they're now gaps. We're going to put people in those gaps to fill up the rest of our law course. So where do they get them from? They get them from other courses who are transferring from, say, arts or joining arts into law, or commerce into law, or economics into law, or biomedicine into law, anything. And that's where they get them from. So they've got to fill up, in the model, the business model for these universities, they've got to fill up those holes. And that's your opportunity if you don't get in the first time. So what I'm saying, there's a lot of different ways to get to the end game of being a lawyer. And don't give up. If you want to do it and you think that's for you, and it mightn't occur to you until you're 25 or 26 or 30, don't give up then either. Just keep at it. Opportunities will open up if you're interested in it, and there's all sorts of ways of doing it. And just briefly, I know I speak too much, but just briefly, I've had 3 associates. They're a person who works with me very closely. Each one of them had that journey, and my current associate is doing her law course here now while she's working for me as an associate. So her journey is, just briefly, is high school, mucked around doing a job or two, and then went off and did a I'm going to call it a politics course, and that was sort of good and bad, you would say. Then she lined up and commenced in the court system here, that is the law department, as a clerk or a registrar, as they're now called. she has worked her way up from the bottom right through this system within the bureaucracy of the law courts. And then my former associate knew her and said, "Oh, I'm leaving my job. You want to work for this grey-headed old git?" And so she put in an application for an associate, and I said, "Oh, that's okay. Yeah, what are you up to with your law degree?" And she told me, and I said, "That's all right. We'll fit that in." So, you know, she's not yet 30, and by the time she is, she's going to have a law degree, and she'll just go over the road here at the Victorian Bar and be a great success. So all I'm saying to you all is, whilst you might think, woe is me, and I understand that, don't misunderstand me, 20 and 21 must have been the worst time in the last 50 years to try and do year 11, year 12 or its equivalent. But let me tell you, it's not all over. The wriggling can continue like the snails on the floor, and all the way to where you want to get. Just don't give up. And welcome when you get here.
Thanks very much, judges. With that, we are out of time, so I would like to extend my thanks to both Judge Chambers, Judge Carmody, and Judge Doyle, who had to leave a little bit earlier. So thank you for attending and having some great answers to the questions. Students, we couldn't do this without you. Thank you for all of the questions you submitted. They were fantastic again. Hopefully we will see you again on our screens. For those of you that won't, good luck with your upcoming exams.